Hello, Omaha, and welcome back to Keep Moving Forward, a table talk for the City of Omaha Human Rights and Relations Department. I'm Lori O'Brien.
And I'm Laura Aryeetey, and we work in the Civil Rights Enforcement Division for our department.
And last time we had the pleasure of hearing from our special guest, Irvin McSwain, who was the longest serving employee in our department.
Yeah, it was really inspiring to hear all of his knowledge about civil rights history and how that led to the department being founded.
Right.
Overall, he was just a really great guy, and I really enjoyed talking with him.
Absolutely, and good seeing him again.
Yeah, definitely.
Yes.
So today we are going to delve more into the investigation division of our department, which, as Irvin explained last time, was the basis for founding the department. So Lori and I are going to be covering the laws we enforce, how to file a complaint, and the investigative process.
And so, and then we're going to begin talking about the laws that we enforce.
Yeah.
And so I'll start by talking about employment laws. And our department investigates allegations of discrimination in the workplace, and we have a work share agreement with the Equal Opportunity Employment Commission, also known as the EEOC. And what this means is that we enforce federal laws that protect you against discrimination when it involves unfair treatment based on one of the following protective bases, and that is race, color, religion, sex, including pregnancy, gender identity, and sexual orientation, national origin, age, which is 40 years or older, disability, or genetic information. And the primary function and purpose of our office is to eliminate unlawful discrimination within the city limits of Omaha in the following areas of discrimination, and that is race, color, creed, religion, national origin, age, which is also 40 years or older, sex, disability, marital status, familial status, which is children under the age of 18 years or younger, sexual orientation, gender identity, and retaliation. These laws also can include harassment. So for example, it is illegal to harass any employee because he or she has a disability. These incidents can include making an offensive remark or offhanded comment, or perhaps singling out an employee who might have missed work due to their disability by discussing their leave with others, which can create a hostile work environment. The harasser could be the victim's supervisor or a supervisor in another area. Another act of discrimination could be the denial of a reasonable accommodation because of a religious belief or a disability. Now, it's important to know that not all employers are covered by the laws that we enforce, and not all employees are protected. This can vary depending on the type of the employer, the number of employees it has, and the type of discrimination alleged. And the last thing to touch on is that these laws are protected employees for asserting their rights. So many people are fearful of retaliation, but it's unlawful to retaliate against employees for being a witness in a complaint, or being a part of an investigation or a lawsuit, or communicating with their supervisor or manager about employment discrimination, which includes harassment that I just touched on. So if an employer retaliates against you because of any of these things, it needs to be reported.
Well, thanks for the information on the employment laws, Lori. So similar to what you talked about for employment, our department also enforces laws that protect people's rights in housing.
Right.
So the housing laws that we enforce in our department include the Federal Fair Housing Act, and then and that's also known as Title VIII of the Civil Rights Act of 1968. And then we also enforce the Fair Housing section of the Omaha Municipal Code,
Yes.
Which is a local or city law.
Yes.
And similar to what Lori, to what you talked about, the housing laws also have a number of what we call the protected classes. And so what that means is the laws prohibit discrimination because of a person's race, color, sex, national origin, religion, familial status, sexual orientation, gender identity, and disability as well. And so you'll notice that there's a couple differences there. So familial status is something that's covered under the housing laws, but not under the employment laws. And that means that a person, familial status is when you have children under the age of 18. Now, the Omaha Fair Housing Ordinance also prohibits discrimination in housing due to age and marital status. And both those laws also make it illegal to retaliate against someone because they have filed a complaint or participated in an investigation. So again, that's similar to the employment laws and those protections. So our office enforces and investigates complaints under the Omaha Ordinance. In addition, as well as the federal laws I talked about. Now we're authorized to do that through a work share agreement with the Department of Housing and Urban Development. So again, similar to the EEOC, which is also a federal agency, we have authority to investigate complaints under Title VIII. And that's if there's a local law that's substantially equivalent to the federal law, Title VIII, or the Fair Housing Act. So what that means for the viewers out there is if they file a complaint, it will likely be filed and investigated under both the local ordinance and the federal law, as long as all jurisdictional requirements are met. So now some examples of specific actions that are prohibited under the fair housing laws include discrimination in the sale, rental, and financing of a dwelling. So for example, it would be illegal to refuse to rent to someone due to their national origin. Discriminatory statements and discriminatory advertising are prohibited. And a person cannot be treated differently in the terms and conditions of tenancy due to any of those protected classes that I talked about. So an example, terms and condition that covers a whole wide range of things in housing, right? But an example of that would be refusal to make repairs to a unit because of a person's sex, evicting someone because of their race or religion, or providing other less favorable benefits of a dwelling because of any of those protected classes. In addition, housing laws also prohibit harassment, and that includes both what we call hostile living environment and sexual harassment. So with the hostile living environment, the law defines that as treatment harassing treatment that is so severe or pervasive that it creates a hostile living environment for someone. So your landlord or housing provider is obviously not allowed to harass a tenant, whereas sexual harassment refers to harassment of a sexual nature that's also severe and pervasive. Now that is, HUD does have an initiative right now that they're really educating the public about sexual harassment in housing.
Right.
Yeah, so it's really important, and that is something that we'll cover more in depth in some of our future episodes, right? Yeah. Maybe when we talk about the hot topics in fair housing.
Yes.
Yeah.
Yes.
So the fair housing laws also have additional protections for people with disabilities. And Title VIII defines a person with a disability as an individual with a physical or mental impairment that substantially limits one or more major life activities. So for people with disabilities, the fair housing laws require that landlords or housing providers make or allow what are called reasonable accommodations and reasonable modifications, and that is for people with disabilities. Now, a reasonable accommodation is like a change or exception to a rule, policy, or procedure, or service that may be necessary for a person with a disability to have an equal opportunity to use and enjoy a dwelling. Also applies to common use spaces. So often we see reasonable accommodations as allowing an assistance animal for a person with a disability if otherwise the housing provider would not allow pets.
Sure.
And another example would be a unit transfer to maybe a first floor. Now, a reasonable modification differs in that that's allowing a structural change to the existing premises. Now, that is at the expense of the tenant, one difference there. And again, it has to be something that's necessary in order to afford the person with the disability enjoyment of the premises. Some examples of that would be like grab bars, maybe installing a wheelchair ramp. And this would often be in buildings that were built before 1991. So that kind of leads into one of the last things I'm going to talk about for the fair housing laws, which is design and construction.
All right.
Yeah,
Yes.
so any building that has been designed or constructed for first occupancy after the date is actually March 13th, 1991, it must meet the design and construction requirements for handicap accessibility. So if a dwelling was built prior to that, it wouldn't have to meet those accessibility requirements, but if a tenant needs a modification, that would have to be allowed. Again, that would be at the tenant's expense.
Absolutely.
So again, and we'll also cover reasonable accommodations and modifications in more detail because there's lots to talk about and unpack in there, right?
Yes.
And that's another one of the hot topics
Absolutely.
in fair housing.
Yes,
So.
absolutely. Wonderful, great. And so then the last law that we enforced would be the Public Accommodations Law. And this is section 1384 of the Omaha Municipal Code that makes it illegal to either deny a person access or treat them unequally in a place of public accommodation because of their race, creed, national origin, age, religion, disability, color, sexual orientation, sex, marital status, or gender identity. And public accommodations are facilities whose goods, services, or premises are sold or made available to the public. And some examples of this would include restaurants or bars, hotels or motels, stores or malls, gyms or health clubs, or hospitals or clinics, just to name a few. And there's others that you can read on our website. And an example of a public accommodations complaint would be not being served at a restaurant because you're a person with a physical disability, or being turned away at a hospital because you're HIV positive. So that's just a few examples of a public accommodations complaint. So those are the three laws that we are covering, that we enforce.
Well, thanks, Lori. And now, you're being the intake administrator for our office.
Yes.
You're going to talk about filing a complaint,
Right.
right?
Right.
Great.
Yeah, so I'd be considered the first point of contact a person would have in our department. So if any person who believes that they've been subjected to unlawful discrimination may file a complaint with our office. So they can either call our office or visit our website and fill out our intake form online. If they would like to meet in person, they can call me and make an appointment in order to do so, because sometimes it's easier to do that,
Right.
Talking to me face to face. And some things to mention that I think are really important. Dates are important, so creating a timeline is very helpful, but it's not necessarily when you want to file a complaint. But to at least have a brief description of the event or events that you believe happen that are unfair is important. And if you don't have that, that's something that you and I can create together. I would help you through that. But it's also important to have any names, addresses, or telephone numbers available of the person that you want to file the complaint against, such as a supervisor if it's an employment complaint, or a landlord if you're filing a housing complaint. So that's just important to have that information handy if you have that. And I also like to mention that a complaint should be filed as soon as possible after the act of discrimination has occurred. So that's 180 days if it's an employment complaint, and it's a 1 year or 365 days within a housing complaint. And I should mention also 180 days if it's a public accommodations complaint as well.
Yeah, right.
So those two. So just to reiterate, 180 days for employment and public accommodations, and 365 days if it's a housing complaint. And complaints must be sworn under oath before a notary public, which is done in our office as well. Most of us are notaries, so
Right,
we can do
yeah.
that. So that's just something, the process that I can walk you through.
Great.
If you want to file a complaint.
Right, and I know you always do a great job and are so helpful to all of the callers, even if they don't have, an actual complaint, but need information.
Oh, absolutely.
And since, you're the guru in our department when it comes to intake, so I was wondering if you could tell us, if someone is unsure if they have a complaint, or if their situation might fall, unsure if it falls under the laws that we enforce, what should they do?
Oh, absolutely. And we do get a lot of phone calls from people who aren't sure, if this is actually an allegation of discrimination. They certainly can give us a call, and I can help them, figure out that. You don't have to know the answer if you, in order to call our office. I mean, I will answer any questions that you have. And if we aren't the right office for you, the right department, I will certainly do my best to find you an agency in the city to help you with that. There's a lot of great communities, support out there,
Right, yeah.
and I will try to connect you with that agency. So
Yeah.
please do not hesitate to give us a call. We have a lot of great staff with a lot of knowledge, so I will connect you with the right support out there. So
Great.
give us a call.
Yeah, and at the end of the show today, we'll have our phone number for our department, so that if you have questions, you can give us a call.
Absolutely.
No, thanks, Lori.
Oh, wonderful. Yeah, thank you, Laura, for those great words.
So, so after that complaint is filed with Lori, then the next stage would be that the file is assigned to an investigator.
Yes.
So I'm actually one of the investigators in the department. I've been working in doing this kind of work for a little over 5 years.
Yes.
So one thing I'd like to just point out is that it's important for everyone to remember that we are a neutral party, and that's because we're a government enforcement agency. And what that means is that being neutral, we don't represent either party in the case or the complaint. So we can't represent the complainant, the one who files the complaint, or the respondent, the person or the entity that the complaint is filed against. Then during the investigation, there will be a review of evidence with the complainant. You might also hear us say charging party. Those are kind of used interchangeably. We usually refer to charging party in employment cases and complainant in housing, but essentially they're the same thing. During that review, the investigator will verbally review the evidence and the response with the complainant, the response to the allegations in their complaint, and that gives them an opportunity to provide any rebuttal statements that they might have. So that's one of the main next steps after filing a complaint. And then from there, the investigator will continue the investigation and gather all relevant evidence, interview relevant parties and witnesses. And again, since we're neutral, the investigator's not allowed to give legal advice or their opinion. However, we always do a fair and thorough investigation of every case. So that we can assure you. Once the investigator determines that all the evidence has been gathered, all the questions have been asked and answered, then the case would go to the senior investigator for review. And the senior investigator, she makes sure that the investigation has been complete, all evidence has been gathered. It's just a second step of ensuring that anyone who files a complaint gets a thorough investigation. When she completes her review, then the file goes to the director of our department, and he makes the final determination on the case. And so that determination would be either reasonable cause or no reasonable cause, and that's based on the evidence that's been gathered in the investigation. And I'd like to point out that during the investigation, we also attempt to conciliate every case. So this is optional for both parties. And so what that means is neither party has to agree to any proposed terms of a settlement, and they don't have to participate if they don't want to. But we do attempt this for every case, and if a mutual agreement can be reached between the parties, between the complainant and the respondent, Then we would execute a no-fault settlement agreement, and then the case would be dismissed. And then the case would not go to a determination if it's dismissed. However, if settlement is successful, one thing that we do look for is to make sure that the complainant or the charging party has it's what the law refers to as been made whole to make sure that they've been compensated in some way for the alleged discrimination. Now that could include monetary damages, a change in policy. We usually do some sort of training for the respondent. And so those are just some examples. So probably another topic we'll get into in one of our future episodes in more detail.
Right.
Yeah.
Now, Laura, how important is it for a charging party or complainant to keep the investigators updated on, if they should move or change their phone number? I know that happens.
Yes, right. Thanks for pointing that out. It's actually very important. We always ask that every complainant and respondent let us know if you have a change of address, and that's really important because we will do our best to always track everybody down. But ultimately, if it's been weeks and months where we can't find the complainant, the case might have to be closed. Right. And if that happens, then you wouldn't ever get the determination on the case.
So you need to keep them.
Yes, it's very important.
Yes, absolutely.
Yeah.
Right.
Thank you.
Thank you. Right. You do a great job of your investigation process. So thank you.
Before we sign off today, we have one more thing that we would like to cover. And that is what we are going to call our Fishbowl Questions.
Yes, absolutely.
So in this fishbowl, we have some of our most frequently asked questions, right?
Yes.
And because we know that there's a lot, so we're going to be drawing a question out of here today to answer and discuss for the viewers out there.
Right.
And this is going to be something that we will do on every show.
Right.
And so if anyone out there has a specific question, you could always email or call that in, and
right.
we will try to put it in here and answer it.
Right, because I know we didn't cover everything.
Right.
Yes.
There's so much information.
Right.
So,
right.
Okay, so let's see.
Go ahead, do the honors.
Okay, the question is, do I need a lawyer in order to file a complaint?
Oh, that's a great one. So go ahead and start that.
Okay, the short answer is no.
Right.
Right.
Yes. Yes.
So no, you are not required to have a lawyer to file a complaint.
Right. I think that's one of the advantages of somebody working with our office, having us, because we are a free service.
Mm-hmm.
But if you choose to, that is up to you. That's not something we tell you cannot do. To have representation.
Right. And it's certainly a complainant's right and also a respondent's right to have a lawyer to be represented. Now they would probably be able to give legal advice that our department would not be able to do. It wouldn't necessarily change the investigation or the outcome of the case. But if someone wants a lawyer to ensure that they can ask legal advice or get more information, it's certainly their right. And we can provide referrals to the Nebraska Bar Association. That's a good place if someone does want a lawyer to find someone who specializes in employment or housing law.
Correct.
Right.
Yes. Excellent. All right. Well, thank you, Laura. So I think that wraps it up for today.
Right. And everyone out there, be sure to join us next time. So next time our topic is going to be focused on COVID and how that relates to employment and housing laws that we enforce. It's kind of a new topic because of the pandemic.
Right.
So there has been some guidance issued out there from the EEOC and HUD. Maybe a couple things that might apply to public accommodations.
Yes.
So that's going to be our main topic next time. So be sure to tune in for that.
Thank you. Mm-hmm. And I'm Lori O'Brien.
And I'm Laura Aryeetey. This has been Keep Moving Forward.
Thank you.